The Jammu and Kashmir governor recently stated that assisting militants in JNK should be tried by investigating agencies under the Enemy Agents Ordinance 2005. This law is more stringent than the Unlawful Activities Prevention Act or UAPA and has the punishment of either a life term or a death sentence. The JNK Enemy Agents Ordinance was first issued in 1917 by the then Dogra Maharaja of Jammu and Kashmir. It is referred to as an ordinance since laws made during the Dogra rule were also called ordinances. According to the ordinance, whosoever is an enemy agent or with an intent to aid the enemy conspires with any other person to act which is designed or likely to give assistance to the enemy or to impede the military or air operations of Indian forces or to endanger life or is guilty of incendiarism shall be guilty with death or rigorous imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. After partition in 1947, the ordinance was incorporated as a law in the state and was also amended. In 2019, when Article 370 of the Constitution was repealed, JNK's legal framework also underwent several changes. The Jammu and Kashmir Reorganization Act was passed, which listed out state laws that were to continue, while several others were repealed and replaced with Indian laws. While the security laws such as Enemy Agents Ordinance and Public Safety Act remained, the Ranbir Penal Code was replaced with the Indian Penal Code. Other laws including the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006 and the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989 were extended to Jammu and Kashmir as well. The trial under the Enemy Agents Ordinance is conducted by a special judge who is appointed by the government in consultation with the High Court. Under the ordinance, the accused cannot engage a lawyer to defend herself unless permitted by the court. There is no provision for appeal against the verdict, and the decision of the special judge can only be reviewed by a person chosen by the government from the judges of the High Court, and the decision of that person shall be final. The ordinance also bars any disclosure of publication of the case tried under it. In fact, if anyone without the previous authorization of the government discloses or publishes any information with respect to any proceedings or respect to any person proceeded against under this ordinance shall be punishable with imprisonment for a term which may extend to 2 years or with fine or with both according to the ordinance. This brings us to the end of our video. If you find these videos informative and helpful for your preparation, please like our videos, share them with your friends, subscribe to Exact IAS on YouTube, and follow us on Instagram. Thank you for watching this. I will see you in our next.